We'll discuss a few more relevant provisions. Let's now go to Section 35, Registry Duty. So, for each registered notice, the registry shall, number 1, assign a unique registration number. Number 2, create a record that bears the number assigned to the initial notice and the date and time of registration. And finally, maintain the record for public inspection. So, yung tatlo na yun ang kailangan nakasulat sa notice, no? So, how does the registry index the notices? So, the indexing shall be by way of the identification number of the grantor. Yun yung parang main ID niya, ang ID ni grantor. And kung motor vehicle naman involved, then they can index it via serial numbers. Next important provision here under Section 35, the registry shall maintain records of lapse notices for a period of what? 10 years after the lapse. So, may duration, di ba, ang notice. After niya na nag-lapse, kailangan pa rin i-keep ng registry yung record na yun for a duration of 10 years, of course, for public information purposes. And another important provision under Section 35, this principle is already familiar to us, no? The duties of the registry shall be merely administrative in nature. By registering a notice or refusing to register a notice, the registry does not determine the sufficiency, correctness, authenticity, or validity of any information contained in the notice. If you remembered one of the cases na diniscuss natin, no, sa chattel mortgage, the registry actually does not have any judicial or quasi-judicial power when it comes to recording information in relation to the chattel mortgage register. In the same manner, the duties of the Register of Deeds is actually ministerial in nature. So very similar, no? Ang sabi naman dito sa Section 35F, the duties of the registry shall be merely administrative in nature. So walang adjudicating powers na binigay sa kanila. Now we proceed to Section 36. Pero dito sa Section 36, you just read the rest of the provision. Ang pinaka gusto kong bantayan nyo dito is letter B. If requested, the registry shall issue a certified report. And this certified report is actually admissible into evidence in judicial proceedings without extrinsic evidence of its authenticity. So remember that. That's very important. Why? If you have a certified report na in-issue, no, ng registry in relation to the notices under the PPSA, it can actually be accepted in judicial proceedings without extrinsic evidence of its authenticity. Malalaman nyo later on in your remedial law that as a rule, if you introduce a document, no, before you introduce it, kailangan mo muna i-prove ang authenticity nito. Totoo ba to? Valid ba to? Hindi ba to ginawa-gawa lang? It's not forged or fake. So those are the things that you should prove first. But if the notice actually came from the registry, you don't need to do that anymore, no? Because it's already admissible in evidence without extrinsic evidence of authenticity. Now we proceed to Section 37. You read the rest of the provision, but I want you to particularly take note of Section 37C, number 2. A security interest in a deposit account shall not require the deposit-taking institution to provide any information about the deposit account to third parties. Why? Because if you actually do not provide for this provision under the PPSA, it would be violative of one of our laws, the bank secrecy law. So it's very important na yung deposit-taking institution would not be forced to give out information about the deposit account of anyone to third parties. So you just read Section 38.